Welcome to UCL and to the Judicial Institute, and welcome to the Right Honourable Lord Dyson, who has a long and close relationship with the UCL faculty, and of course was awarded an honorary doctorate in 2014, I think. I'm delighted, John, to have this opportunity to discuss with you your career and reflections on that and life more generally. And of course, the conversation is prompted by your book, Judge's Journey. And I confess that when it was first published, I didn't read it very thoroughly. I did what many lawyers, I suspect, would do, and I skimmed through looking for the interesting cases that I knew you decided to see what you had to say about them. So this has been a more diligent exercise by me in reading through. And I've been struck by how much more personal and candid an account yours is than many judicial memoirs. Perhaps I can begin by asking you what it was that stimulated you to write the book in the first place.
Yes, well, good evening to you and to everybody who's come along. And it's a great pleasure to be here, although it's rather strange because I'm sitting at home. What caused me, it was a number of things. One was that I had for some time thought that I might write some sort of memoir for my family, which is the thing that's usually the stimulus for this kind of thing. When I retired as Master of the Rolls in 2016, I had a valedictory in the Lord Chief's Court in the way that senior judges have. And I gave really quite an unusual speech in which I talked about my family background, my European background, my Jewish background, and talked a bit about my grandmother, who had spent some time in Belsen in the war. And it was really a valedictory speech unlike any other, I think, that had ever been given. They're normally kind of fairly light, self-deprecatory affairs. And so many people said to me that how moved they were by it, and they'd like to know so much more. So I think it was a combination of the response to that speech and a desire on my part to write something for the family anyway. The two of them coming together was really what led me to write the book.
Thank you. It certainly is, as I said, a very candid account, and those early chapters where you're describing your ancestry, very, very important and clearly have an influence. I want to come back to that. But you mentioned there that was your valedictory, having retired as Master of the Rolls. And in many senses, your career followed a traditional path for senior judges. You were a barrister, QC, assistant recorder, when we had such things, recorder, High Court judge, and so on. But then you reached the pinnacle in the Supreme Court. But in many respects, it's also unusual because you stepped down from that, albeit to be the Master of the Rolls. You went from the Supreme Court back to the Court of Appeal, which was a very unusual thing to do. Of course, Lord Denning did that. Having held those two posts, perhaps you could say a little bit about your experience of the different roles and what it was that led you to move back to the Court of Appeal.
Well, I've been asked that question many times. I mean, to say that I wasn't the first to have done it and that Lord Denning had done it and David Newberger had done it, and I think one or two others had done it, that isn't really a very satisfactory answer. Frankly, I'd been in the Supreme Court for only a little over 2 years when it was Lord Judge, who was then Lord Chief Justice, said to me, might I be interested in doing this, because he knew that Lord Newberger, who was then the Master of the Rolls, was possibly going to leave that position and take up the position as President of the Supreme Court when Lord Phillips retired. Frankly, it had never crossed my mind that I might do anything like that at all. And my first reaction to Igor Judge was to say, well, I'm much too old anyway. And he brushed that objection aside with his usual charm. And it then got me thinking. And I've as I think I say in one or two other places in the book, I've always found it difficult to resist a new challenge. And this was indeed going to be an enormous new challenge if I took it. What was slightly odd about the decision was that it had taken me a little time to settle down in the Supreme Court, but I had settled down and I was enjoying it enormously, and I think I was making quite a contribution there. To leave all that after such a short time did seem a slightly strange thing to do, and ideally I would have not wished to do it until I'd spent at least another 2 or 3 years in the Supreme Court. But that possibility was never going to arise. I mean, I was either going to take this Master of the Rolls job then or never. And it just seemed a very exciting thing to do. And it wasn't just because I liked the name Master of the Rolls and its ringing historical kind of feel. It was going to be something very different, and I thought it would be very exciting. I suppose, if I'm honest, the attraction of being in charge was of some significance. I had, throughout my judicial career, I had never been in charge of anything except when I was put in charge of the Technology and Construction Court by Lord Bingham for about 3 years. And I have to admit, it may not reflect very well on me, but I have to admit that I do quite like being in charge and running things the way I think they should be run. And I suppose in the Supreme Court, if I'd stayed until I was retirement age, I was never going to be in charge. I might have presided from time to time, but I was never going to be in charge. So that was another factor that I think attracted me.
That's two interesting things I think flow from that. One, I get a sense from various other decisions that are made apparently in the book that you do make these bold decisions, moving from chambers when you've been so well established at 10 Essex to go and become head of chambers at a new set, another set. And I hadn't really associated that with being a lust for power, but maybe that's what it was.
Well, that certainly was not a question of lust for power. I mean, I was invited to become head of chambers at what was then 2 Garden Court, which is now 39 Essex Chambers. And I mean, the attraction of being head of chambers was not an attraction for me, frankly. And being head of chambers is a pretty thankless job. No, the attraction for me was that I had been doing, for many years, been doing construction cases. I'd never gone to the bar thinking that's what I wanted to do. I mean, my life, a lot of it has been just following where circumstances took me. And so I found myself doing a lot of construction work, and I was successful at it. But just once in a while, I got other work. I remember a couple of clinical negligence cases, which I found absolutely fascinating. And I realized that there was a great big world of the law out there, outside construction work, which looked as if it might be a lot more interesting. But, and when I told my clerk at 10 Essex that I'd like to do more diverse range of work, he said, "Leave it with me, sir." But I knew that there was no way that I was ever really going to shift sideways if I stayed in specialist chambers. So the attraction for me of the move was that I realized that the only way that I had any real possibility of making a significant shift in my practice would be actually to move chambers. And so that's what I did. It was not a quest for power at all.
No, quest for interest rather than the construction court. Who can blame you? But also a point that arises there in relation to your discussion about taking on the post as MR, the age of retirement. Do you think we force judges to retire too early?
Well, I do actually. Yes, I mean, I think 70 is too early for people who have made it to the top of the judiciary, and one hopes in most cases still have got all their faculties, their mental faculties, they've still got energy. It does seem a terrible shame to force them to retire. And what is also happening is because the retirement age was reduced to 70. Quite a lot of judges don't actually wait until they're 70 to retire. They retire in their mid-60s in order to have a new career as an arbitrator or something of that kind. And so there's a great loss, I think, to the system of really extremely able judges. And I appreciate that in most areas of life, 70 seems quite old enough to retire. But I do think that in this particular area, 70 is too young. I thought at the time when I was still at MR that maybe we could go back up to 75 for the Supreme Court and the Court of Appeal. But it was quite clear to me that politically that would simply not be on, because the magistrates and the lower judges felt just as strongly that they had all their faculties and their energy, and they would have wanted to go on to 75. So I don't, although logically in a way, there is a real case, particularly with the Supreme Court, because it takes, in most instances, I mean, I leave aside the exception like Lord Sumption who goes straight from the bar, but in our present system, most people do as I did, you work your way up. So if you work your way up and you have to stop at 70, there's not much headroom to have a good period of time in the Supreme Court.
Just staying with the Supreme Court for a moment, did you miss that rarefied atmosphere, your description of the Supreme Court, although in parts a description of a rather lonely existence? Did you miss some of that rarefied atmosphere when you stepped down to the MR's role?
I didn't miss the rarefied atmosphere because I actually positively enjoyed being back in the Royal Courts of Justice or in the Strand, close to my inn. It was a much buzzier place. There were lots of people. The Court of Appeal had about, I think, 38 people in it. You sat in groups of 3, so you were sitting with lots of different people, whereas in the Supreme Court, you were 12, you normally sat 5, at least 5, and you had lunch together in Parliament Square, and it did feel quite cut off. And if you like being with people, as I do, I found being back in the Court of Appeal more fun, and although I loved doing these difficult and important cases in the Supreme Court, and I got my fair share of those as Master of the Rolls, but I also enjoyed doing some cases which were rather less rarefied and rather closer to trials. I mean, some of the procedural cases that I decided, which were extremely important. I know that some people are a bit sniffy about procedural law as being an interesting subject, but I don't share that view. And I think procedural law is enormously important. And I had to decide some very, very important cases in that area, which I would not have had in the Supreme Court. So all in all, I mean, you can't have it both ways. I loved the, if you like, what you call the rarefied atmosphere of those cases and being able to concentrate on a smallish number of really important, interesting cases. But I felt as Master of the Rolls, it was much more lively. I decided quite a lot of those really important cases, but I had to accept the fact that, of course, in quite a number of them, not all, but in quite a number, I didn't have the last word, and there would be an appeal to the Supreme Court, and that could be a bit frustrating. But you have to make a choice. You can't have it both ways.
I was interested in one of the comments that you made about when you were sitting in the Court of Appeal. I think it was when you were sitting in the Court of Appeal before your elevation to the Supreme Court, about how important it was that the constitutions of the Court of Appeal, sitting as a tribunal of 3, weren't always experts. It didn't bring together necessarily a constitution of 3 judges with expertise in relation to the particular fact or area of law in the case. And you saw great merit in that. And I just wondered what your reflections were on this balance between the breadth and experience that judges bring from their different experiences in practice and first instance, and whether that was even more true in the Supreme Court, whether in the Supreme Court, when you're dealing with these issues of huge policy, whether actually what we need is breadth rather than depth of expertise.
I do think that. I can remember, I actually remember Lord Hughes, who you will know well, because of course he was a great criminal lawyer, but no doubt still is, and he's still alive. And I remember sitting with Anthony Hughes in the Court of Appeal, when he was still in the Court of Appeal, in a civil case, quite a difficult civil case. And I mean, his contribution to that case and the discussion in it was tremendously impressive. And I mean, he didn't, of course, bring his criminal expertise to bear on that case, but it just brought home to me how somebody of real ability can really turn their hand to a whole manner of areas of the law. And I think the solution to how you manage a court for a particular appeal, ideally, is that you certainly should have at least one member of the court who is a so-called expert in that field, who knows and has a good feel for it and what works and what doesn't work, and just knows his or her way around. But I really do think that it is also of great benefit to have somebody who's not so steeped in it, who doesn't have, who comes to it fresh and doesn't just have a kind of a view about a particular topic which they've held maybe for years and almost stopped thinking about it because they've had that view for many years, and somebody who really has to work at it from the beginning and can question the received wisdom. I think that's tremendously valuable. So I think so the ideal is to have a mix.
So in terms of manning the Supreme Court or constituting the Supreme Court properly, what do you think the most important preparation for you was? Was it your career at the bar? Was it your experience as a judge? Should we anticipate a Supreme Court with exclusively practitioners? I don't think Lord Burrows is listening this evening, so you can say what you like about academic appointments. How could we ensure that we have the best constitution in the Supreme Court?
Well, I think having an academic appointee like Lord Burrows is terrific, and we know from other jurisdictions that they are they're much more willing to appoint to their top courts people who have had academic careers than we have historically been in this country. And I think that it's good that things are loosening up a bit. Again, it's having a mix. I do think that you need, particularly at first instance, and probably the Court of Appeal, but certainly at first instance, you do need to have judges who know their way around how the thing works. Who, my own view is, but maybe I'm conservative, I hope not, but it is an advantage to have been involved in litigation as a practitioner. You know, you sit up there as a judge and you see what goes on and you know what's happening. You can see, it's amazing what you can see. You see the barrister, you see the solicitor behind the barrister tugging the barrister's gown. You understand the pressures that the barrister is under because he's got a difficult client and a solicitor breathing down his or her neck. Because you've had all that, you've been through all that, you understand it. You understand that sometimes submissions are made which you can just tell the advocate doesn't really believe in, but feels has to make them, all that. You build up experience of court craft and understanding the kind of conventions and the rules of the game. And having all of that is, I think, an enormous advantage. But at the higher levels, the appeal levels, when the law really gets made, I think that what really counts there is not so much on the understanding of how litigation works, but about the law. And academics, you don't need me to say this to you, but I mean, academics have the advantage that they spend their lives thinking about the law, studying it in depth, reading around the law in a way in which a practitioner simply can't. So I think the traditional route, saying you have to have been, well, until recently, you had to have been at the bar. I mean, now at least solicitors are being let in, but you traditionally had to have been at the bar, and then you had to work your way up the system, High Court, Court of Appeal, then possibly House of Lords or Supreme Court. I think that's too rigid an approach. And I do think that it's a good idea to have a mix, and that mix should include some academics, but I would not wish the Supreme Court to be packed full of brilliant academics. I think you've got to have that mix and have people who have experience of how the law works in practice. Because ultimately, the judgments, I've felt this very strongly, judgments have got to be practical. And however brilliant the legal analysis, and I love writing judgments and analyzing legal problems and all that, and trying to express myself clearly and all that. But ultimately, the judgments serve a purpose. They're not academic treatises about how the law should be. They have to be have utility. They've got to be one. The legal profession has to understand them and to be able to use them without too much difficulty. The judges in the lower courts have to understand them. I spoke about this quite often in lectures that I gave, and for some reason I always talked about the Sunderland County Court. I don't know why I picked on the Sunderland County Court, but I picked on the Sunderland County Court, and I said, just ask yourself whether the district judge or the judge sitting in the Sunderland County Court, who doesn't have access to a law library, doesn't have the time to do the research, is probably addressed by, or maybe addressed by the local solicitor or the local barrister. And your decision in the Supreme Court or the Court of Appeal has got to be one which that judge can readily understand and apply. I think that's so important.
The significance there in the practical effect of those decisions, I completely agree. In terms of the significance in policy terms of some of those decisions, that can't be ignored either. I mean, you were involved in so many cases with really difficult moral, ethical dimensions to them, political dimensions. At the bar, you were counselling the Rants and Mid-Downs health case, which you describe in the book, the so-called wrongful life claims. On the High Court, you were involved in cases, the Literal Democrat case, the case challenging whether or not there was confusion on the ballot paper. And in the Court of Appeal, of course, you were involved in Nicholson on assisted suicide, and the case of Black and Morgan, the bed and breakfast owners who denied the room to the gay couple and so on. I mean, do you have reflections on those? Particularly, how much can a judge divorce his or her own morality when making those decisions? Those really difficult moral questions, are they always susceptible to legal resolution?
Well, that's a huge question, of course. I mean, the first question is whether it's something that the judge should get involved in at all. The justiciability issue, which is a very current live topic, as you know, and many people will know. We've got the Lord Folkes inquiry looking at judicial review, whether judicial review should be codified, whether justiciability should be tightened up and not left to the judges, but should be the subject of statute. All, I think, inspired by the government's fury at losing the prorogation case, I'm afraid. So that's the background. The first question in these very difficult cases involving policy and politics is whether the court should get involved at all. And you mentioned the Nicklinson case, and that's a very good example. The question of whether or not the court should get involved in declaring that the legislation which makes it a crime to assist somebody to commit suicide is incompatible with Article 8 of the Convention. And I was involved in the decision when I was MR in the Court of Appeal, and we said it was a matter for Parliament. In the Supreme Court seemed to me to be all over the place on this, and they've written long and rather difficult and to some extent, I say probably unfairly, slightly confusing judgments. But anyway, they certainly 4 of them out of the 9 said that it was not a matter for the courts, it was a matter for Parliament. I think 3 of them said that it might be a matter for the courts, but we should give Parliament another go at it. So this is a very difficult area, and there are others. There's another decision of mine which I'm sure you're aware of, the case of Al-Rawi, which was the case about whether the courts, the judges, could, as a matter of, by evolving the common law, introduce a system for closed material proceedings in cases involving national security. And I wrote the lead judgment in the Supreme Court, and we said, no, this was a matter for Parliament. Very controversial, very difficult. This isn't really for the courts. So I think you put your finger on a very important point, because the courts are now being asked to decide things which a generation ago they would not have been asked to decide. And I think the judges are still feeling their way as to how far to go. On the whole, most judges, I think, are pretty cautious and are only too aware of the fact that they're not elected, that we have a parliament which is elected, only too aware when it comes to deciding whether or not the executive has acted unlawfully. I mean, we ultimately, the judges are only concerned with whether there's been a breach of the law, but I appreciate that that begs quite a lot of questions. But the judges are only too aware of the need to exercise restraint in this area. I gave a lecture on, in fact, it was the Bentham lecture that I gave a few years ago on whether the judges have become too powerful. I know Lord Sumption thinks that they have. I don't happen to agree with him about that, but it is a controversial and difficult area, and it's moving. Things are not static. The Convention on Human Rights, of course, has made a big difference to all of this, because if I can just interrupt myself for a moment. I mean, one of the fascinating aspects of all of this, I think, is that the judges have evolved the common law in really quite remarkable ways. And not just recently. I mean, you go back to something like Donoghue and Stevenson. You know, this is a massively important case. Really, frankly, far more important than some of these eye-catching cases like the prorogation case, I think, in the sense that it affects the lives of millions of people, has affected the lives of millions of people. And this was the result of the judges moving the law along. And I don't think that there were any howls of protest about this is a matter of Parliament, this is, what are the judges doing here? And then you have all these cases on like the cases on immunity from liability, professional, the barristers and solicitors' immunity from liability, which now has been rowed back from. That's all created by the judges, and that there have been no howls of protest, as far as I'm aware. There have been no howls of protest about what on earth are these unelected judges doing. This is something for Parliament. So I think it's quite important to bear all that in mind when we turn our thoughts to what's now been happening more recently, particularly in relation to the European Convention on Human Rights.
I suppose that begs an obvious question, which is, you referred there to the unelected judges. Do you think that there is the prospect of a US-style appointment to the Supreme Court, at least? Would you have any views on some kind of parliamentary hearing as to the suitability? People who say, I need to understand the judge's moral, political, ethical stance before I have judges making these decisions, which, as you say, can affect millions.
Well, you wouldn't expect me to agree to that, I'm sure. And of course I don't. We have a very different system here, and indeed, I think the shortcomings of the American system have been highlighted very strikingly, only very, very recently. But we have a different system here. We don't have a written constitution, so that, and we do have a system in which ultimately Parliament is sovereign, and I think that makes an enormous difference. Having said that, I don't deny that judges have great power. They clearly do have great power, and it's a perfectly legitimate question to ask. Well, before they're appointed, well, how are they appointed, first of all, which we can talk about. But secondly, in the appointing process, it should, or even perhaps, yes, well, as part of that appointment process, should the public not be made aware of the views of these judges on some of these moral and political, with a small p, issues? And I mean, my first response to that is, well, let us just suppose that the public were told that John Dyson is on the liberal wing, whatever that means, and he's pro-human rights, whatever that means. Suppose that the public is told that. Well, where do you go from there? I mean, you know, I just don't see the point of it. And then you've got to remind yourself that a lot of the work that is done, certainly in the Court of Appeal and even also in the Supreme Court, has nothing to do with politics or morals. It's about the law in the classic traditional sense. And there've been, when I was in the Supreme Court, I think quite a high percentage of our work was public law / human rights law. And I think still a lot of it is, but I didn't sit on many straightforward common law cases or statutory interpretation cases. My sense is that there have been rather more of those cases in the recent. There have been a lot of contract cases. So you really do need excellent lawyers to decide those cases. I just feel that to have an American-style approach would cause a lot of chaos, and I just don't see what would come out of it that could be of benefit.
You touched there upon the appointment of judges and how we appoint judges generally. Whether we have a pool of judges that's sufficiently diverse is an obvious concern. You were the chair of the Ethnic Minorities Advisory Committee in the 1990s. I wonder whether you have views on whether the current system works well, whether it's preferable to the tap on the shoulder, and your book describes in quite striking terms the way that those operated, a phone call and a proposal from the Prime Minister as to whether you would be appointed and so on. How can we achieve a more diverse judiciary, and what do you think the benefits of the current system, the Judicial Appointments Commission, are?
Well, the first point to make is that there can be no going back to the old tap on the shoulder system. I do think that was a pretty appalling system, even though I think I was a beneficiary of that system, but I do think that somehow or other, some very good people were appointed to the bench. I'm not talking about myself, but I mean, they did manage to find some very good people, and they had must have had a very good surveillance system, the Lord Chancellor's department and the people who were in it, because I mean, I wasn't a high-profile lawyer, and somehow or other they found me out. David Neuberger was not a high-profile lawyer. They found him out, so they were quite effective. But as a system, it really, I think, is indefensible. And not only is it indefensible because it inevitably meant that a lot of the appointees tended to be drawn from a very narrow class of people, namely successful barristers, and therefore excluding a lot of other potentially excellent candidates. But it also, because there was a certain amount of consultation amongst the senior judiciary, and I can remember going along to meetings with the Lord Chancellor when names were being bandied about, and this small group of senior judges were being asked for their views about X, Y, and Z. And I know because I've been told anecdotally that there were some successful barristers were blackballed by senior judges, and they never made it to the High Court. And all you needed was one very senior, one master of the rolls or something, to say, well, I don't think we can have him, or and it was always a him. And that was it. So it was a very, very bad system. And what we've got now is definitely better. The Judicial Appointments Commission, and I saw it in action, because whilst I was Master of the Rolls, I sat on the meetings of the Judicial Appointments Commission for appointments to, certainly all the appointments to the Court of Appeal when I was Master of the Rolls, but also some of the very important appointments like the Chief Justice and other big important positions. And I've seen how it works at first hand, and it was, I think it's probably better now, but it was very process driven and a rather sclerotic sort of thing, and frankly, people who were being asked to respond in the consultation process were tearing their hair out in the way it was done. So, but I'm out of touch now, but I think it certainly needed improving, and I understand that it has improved. And that was a big step in the right direction. As to whether we're now getting towards the right balance, well, progress has been made. There's no doubt about that, in my view, but there's still quite a long way to go. The gender balance is getting better. It's still got some way to go, but it is getting better. And I don't agree with what Sumption said some time ago, that it would take 50 years to get a good gender balance in the Supreme Court. I don't think that's right at all. And there are some excellent women who have recently been appointed to the High Court and the Court of Appeal. And once excellent women are appointed, then other excellent women who might be thinking of doing it will be much more likely to apply, because they see that their former colleagues are doing it. And this snowball effect, I'm convinced, is already beginning to happen. And it is the way forward. I think there is scope for attracting more solicitors and academics, where we've talked about academics. And I think it's difficult for academics at first instance. And if you're going to just parachute them in at the highest level, but then I think you've got to be very, very careful about not overdoing that, because it's very demoralizing for the troops lower down the ladder who have ambition, who are excellent, have ambitions to go all the way, to find that somebody's just been parachuted in from outside. I'm not saying it shouldn't happen, but I think one should be very cautious about doing it too often. The big problem, which has not yet been solved, is the ethnic minority side of things. And there are lots and lots of excellent ethnic minority lawyers. The problem has been to persuade some of them to apply, because now that we've moved away from the tap on the shoulder and there's no going back, the Judicial Appointments Commission can only appoint from people who apply. And so the key is persuading people to apply. And I'm not now sufficiently close to what's going on to be able to shed any light on this and what is currently happening. But there is a real desire on the part of the Judicial Appointments Commission and the senior judiciary to attract more people from the ethnic communities to the bench. And it is now, I think, it's becoming a really critical need. But the need is understood. It's a question of how you achieve it.
Yes, I'm conscious of the time, and I wanted to ask you some questions about the influence of your childhood, your Jewish culture, and so on your life and on your family life more generally, which you give a very frank account of in the book. I think in your reminiscences on the childhood throughout the chapters in the book, it was apparent in several places just how keenly you felt the wrongs that were perpetrated against you and others, the anti-Semitic taunts, the bullying, and so on. And I wondered whether that was something which you felt had really developed your character, which was deeply ingrained in your character and had an impact on your career professionally.
Well, I really can't answer that question. I mean, it is very difficult for anybody, I think, to say what have been the influences on one's life which have really been paramount. I think probably the Jewish factor has been important. I'm not a religious person, but I'm very conscious of my Jewish identity. I've never been the victim of anti-Semitism personally. I have seen, and I describe in the book, one horrific incident at school from a school teacher. And I think that probably did make a mark, because I can still hear the school teacher's voice resounding in my ears after all these years. So that's quite remarkable. I think it's really difficult. I mean, who knows what it is that makes one the way one is? It's something that I'm very interested in when it comes. I mean, I'm considering possibly writing a book about judges and what it is that causes certain judges to decide cases one way and other judges, all no doubt just as good lawyers, deciding cases a different way. And I think that's a very, very interesting question. I think I was seen as a very progressive judge, and I regard that as a good thing. I'm not sure I don't think I've really answered your question, but I'm not sure I can do much better.
No, I think I was struck by how there was obviously, you had an innate sense of justice. Being accused of cheating wrongly at marbles by no less than Sir Nigel Rodley, although he was only a primary school child at the time, clearly left its mark. So it was obvious that you had this strong sense of justice. Just in relation to your personal life, family life, more specifically, you give a very frank account of suffering from ME and depression. And I just wonder whether you had any thoughts on the way the legal professions are approaching mental health. The work-life balance within the legal profession is not always a healthy one, and I'm sure that's true on the bench.
No, well, I mean, the ME episode, which lasted about 2 years when I was in the Court of Appeal. And it was really very, very hard. I mean, I knew nothing about ME. And it just came out of a blue sky. I'd had a small infection, and I was left with this terrible tiredness and inability to do very much. I was able to keep the working just about. I remember that it was Lord Judge who told me after I said I was not feeling at all well. He said, "Go home and don't come back until you're better." Well, if I'd done that, I would have been away for 2 years. And so, and you know, he meant well. Of course, he meant well. I don't know whether things are any better now. I don't think, certainly in my day, the system really didn't take much trouble about mental ill health. And I mean, I know other people who suffered far worse than I did, but suffering from ME, not knowing whether you're ever going to come out of it, and if so, when, it's not surprising that it causes depression. And the depression I had it gave me a real insight into what clinical depression is. When you just, you know, your mood is so low, you don't want to see anybody and all that kind of thing. And I think it's only if you've experienced it that you understand what it's like. And the system simply wasn't geared up to dealing with this kind of thing at all. It's fair to say that when I was in the Court of Appeal and I came back to work within a week of going home, I went home thinking I would be able to start rereading things like Tolstoy's War and Peace and so on, but that didn't happen. But when I got back, they gave me shorter cases, and I was spared going out on circuit. The Court of Appeal went out on circuit. I was due to go out on circuit, and that was changed. So, to be fair to them, they to that extent they did accommodate the problem. But I don't think. I mean, I hope things are better now. I think there's more of a general understanding in all areas of life of mental illness and the damage it can do, and how important it is to understand that.
I think it was so striking, because I sense from your book that you are an optimist. There's a line I recall from, I think, when you were a teenager at Leeds Grammar School, when you say at some point in the 1950s, these seemed like good times to be alive. And anybody who reads the book will see that there's this tremendous work ethic, obviously, throughout, but also a spirit of adventure. You decide one summer that you will walk with one of your university friends. You will walk to Rome and so on. Just this sort of daring do, this spirit of adventure, which isn't what people might perceive a senior judge's background to have been. So I think I was particularly struck by when you have that background of eternal optimism for somebody to be struck by that level of depression was obviously quite remarkable. I know that we have a series of questions lined up, so I'm just going to ask you one final question, if I may, which is about what might have been if it wasn't the law. And again, those who delve into the book will see that the law is lucky to have you, because if you hadn't had appendicitis and you'd stayed on and finished the year in your final year studying classics, then you were seemingly destined for a career as an academic in classics. And do you often reflect on that and think, well, I could have held that academic post? Now you refer somewhere in the book to having a starry-eyed admiration for academia. I wonder if on occasions you look back and think, I wish I'd stayed with the classics.
Well, I mean, I married an academic, so that I was sufficiently starry-eyed to marry an academic, but I didn't marry her because she was an academic. And no, I loved classics. I was going to spend a year at Cornell University after graduating, but that didn't come off because I had this operation. And I kept in touch with one or two of my classics friends from my Oxford days, who've been very successful classicist academics, and I think to myself, I've had so much a richer, for me, so much richer a life than I would have done if I'd remained in that world and as an academic. I've just been very blessed because I've found the law so interesting, so many dimensions of it is so interesting. It is intellectually very challenging, and I mean, I still enjoy, I'm doing a certain amount of arbitrations and that sort of thing. And I only today finished writing an award, which is really a difficult award, and raising some difficult questions of law. And I still, oddly at my age, still enjoy crafting a judgment and trying to sort out a knotty problem. But it's been so much more than just writing judgments and hearing cases. It's been meeting lots and lots of wonderful people. I felt it's been so relevant to the modern world, to the here and now. I've been lucky to have visited lots of countries when I was senior judge and master of the rolls, given lectures all over the place, and have just had a wonderful life. So I couldn't have hoped for anything better, and I have no regrets that I didn't remain as a classicist, an academic classicist.
I think that's clearly the law's gain. Perhaps I can turn to some of the questions that have been posed by delegates this evening and some earlier. I could start with one which has been asked by Preetam, which is, do you think the Supreme Court should be granted the authority to strike down legislation, as in the US courts, the US federal courts, especially during a time of Brexit and Parliament regaining regaining complete sovereignty?
No, I don't. I think that the Human Rights Act was a brilliant piece of legislation. I don't know who thought up this idea of giving the courts the power to grant declarations of incompatibility, but to stop short of saying that they could actually strike down. I think it was a stroke of genius, whoever it was. You may know who it was. I don't know who it was. And I mean, of course, we all know that grants of declarations of incompatibility usually lead to a change in the law. So, but it doesn't. It stops short of that, and I think that's a far more acceptable balance to strike between the powers of the judiciary and the powers of Parliament. I just think that it seems to me to work very well. That in most cases, if the judges say that the law doesn't comply with the convention, then Parliament will change. But in the occasional really, really important case where Parliament says, well, we've heard what you judges have to say, but we're going to stick, then I think that's fine. And I think it maintains a good balance.
Another sort of question in the same sort of area, really, from Professor Tammy Harvey at Sheffield, who wrote in earlier with a question. Do you think that one of the biggest threats to the UK at present is the vogue for supporting the political constitution in the name of populism? Perhaps I can link in with that. Another question from Irene Mansfield, who is retired. It was a UCL alumna. Are you concerned about attacks on the independence of the judiciary by the executive and the legislature? So this question about the role of the judiciary within that political context. Well,
I don't detect attacks on the judiciary by the legislature, but the question of the attacks on the judiciary by the executive is a different matter. And I think judges, including myself, have got to be careful not to be too thin-skinned about this. It's perfectly fair, I think, for judges to be criticized. There's nothing wrong with that. And indeed, I think if judges could not be criticized, that would be a very bad thing. I think it's the way it's done. And I think judges have got to understand also that politicians are politicians. And the attack on the attack recently made, which led to the Daily Mail Enemies of the People headline over the first of the Brexit cases, was, I thought that the headline was awful, but then it was the Daily Mail, so you could say, well, what do you expect? I thought that the lily-livered defense of the judges by the then Lord Chancellor was pathetic and woefully inadequate. But it's very easy to forget that, these sort of things have happened before. I was reminding myself and just thinking about this evening and just dipping into my one of my lectures, I think, that Home Secretaries in the past have spoken in vitriolic terms against judges. There was John Reed was a Home Secretary, I think, at one point. Blunkett, another one, who was furious that he couldn't deport some asylum seekers, I think it was, and spoke in the most outrageous language against a particular judge. So, I have myself, I was a signatory to a letter to The Guardian only the other day, criticizing Priti Patel and the Prime Minister for what they said about lawyers as a class and representing these activist lefty lawyers representing asylum seekers and immigrants. I think actually there is a bit of a difference between the kind of onslaught of Priti Patel, which is to castigate lawyers as a class, not an individual judge whose decision they can't has infuriated them. And that's why I signed that letter, because I thought to actually to say that all lawyers who do this sort of work effectively are behaving without integrity and irresponsibly. I thought that was just going far too far. But attacks on individual judges for individual decisions, I'm afraid that's something judges have got to put up with. I was a victim of that. Victim is the right word, I don't think it is, of that sort of thing from Michael Howard in the 90s. And judges have got to be prepared to put up with that, I'm afraid. It just goes with the territory. I don't think those sort of attacks really do amount to a threat to the rule of law. I do worry about the sort of attacks that Priti Patel and Boris Johnson made on lawyers of a particular class doing a particular kind of work, representing vulnerable people who are, in many people's eyes, are not popular. I think that's highly dangerous.
Yeah, somebody has asked, actually, one of the questions that somebody's asked about more experiences of your time as Master of the Rolls. Well, I'm going to encourage them to buy the book and mention that they can get a 20% discount on the book, I think, as well, from Heart at the moment, if they do that, because you do give some very good examples of your work as Master of the Rolls. And you also, on this particular point, give a very clear account of hearing Michael Howard on the Today programme criticising your judgment, and that the impact that you felt from that personalised attack on your decision making. Moving to something less political, a couple of questions about the impact of the COVID-19 pandemic. One in relation to how do you envisage the technology being used in the future, and what risks are there in relation to the use of the technology for the court. And linked to that, Stuart McMillan, who's a policy analyst at the Bar Council, asks, do you think that alternative dispute resolution can play a role in decreasing the backlog of cases which has been generated by the pandemic? So how are we going to respond to the pandemic in the courts? Does the future lie in technology, alternative dispute resolution?
Can you hear me? Yeah. I think in civil cases it works well. I have done a number of hearings this year, remote hearings with I know that there's quite a lot of remote hearings taking place in civil cases in our courts already, and I think there's probably no going back on that. Are rather different, and I know that there are those who think that there's simply no way that we could contemplate having jury trials dealt with remotely. And I was at a meeting of justice. I'm on the Council of Justice the other day, and Baroness Helena Kennedy, who's I think the President of Justice, was very, very strong about this, and she was more or less berating civil practitioners for not understanding of criminal law. And you cannot, she said, you cannot have juries online. Justice has actually done some very interesting work on this, and they've piloted various studies. I don't know whether they've received the publicity they deserve, but they ran a series of different pilots, the last of which involved having a jury all in one place. Because if you have juries, all 12 of them in their different homes with their different devices, you're going to be in real trouble. But this idea was that you had the jury in one place with technical backup to make sure that all worked well. And there was a retired circuit judge who presided over the trial. And the general feeling was, and it was monitored by an academic criminal lawyer. And the general feeling was that it worked extremely well. Now, I know the counter argument is that you don't see you don't get the body language, and you can't assess witnesses as well on a screen as face-to-face. And I think that's probably right, although I think the technology is improving all the time. And the backlog of criminal cases in the Crown Courts now is horrendous. So I cautiously think that this is something that maybe should be explored further.
Thank you very much, John. We started to lose your connection there. You froze a few times, but I certainly heard the gist of that. I wonder if it's appropriate to begin to draw things to a close if the connection's starting to waver. There are a series of other questions in the chat function, people asking about whether you think in relation to sports dispute resolution, there are developments that can be made, how we deal with some unconscious bias in all levels of the judiciary, and whether we end up moving towards artificial intelligence and robotic judges if we don't allow judges to influence cases by their own personal backgrounds and so on. We don't have time to deal with all of those. I had so many more questions that I could have gone on for at least another hour, but I won't. I'm sure there'll be an opportunity for us to do that on another occasion. In fact, I hope there'll be another opportunity when you write the second book, the next book, which I can look forward to. But thank you very much for being as honest, as completely candid as you have been in conversation as you are in the book. And I do recommend for those who haven't yet read or have only skim read as I did, that it is well worth reading in full. So, Lord Dyson, thank you very much indeed.
Well, thank you very much. I've enjoyed it very much. Thank you.